Okay, thank you. A very good morning, everyone. A warm greetings from Southern College of Engineering and Technology in coordination with Institutional Innovation Council, an initiative by MHRD, is inviting you to the webinar on patent and IPR. Welcome everyone for this webinar. The Southern College of Engineering and Technology was established in the year of 1994 by the Southern Educational Society, formed by Dr. Muhammad Nizarat Rasul Khan. With the blessings of Dr. Muhammad Nizarat Rasul Khan, the founder, with the leadership of Mr. Muhammad Shah Alam Rasul Khan, our chairman, with the constant motivation of Dr. Atikur Rahman, our principal, with the support of Dr. Munim, the Director Administration, Dr. Srinivas, Director Academic, we are organizing this webinar. On behalf of everyone, I would like to welcome all the participants. I would like to invite Mrs. Nisba Gozar Madam to introduce our today's resource person. Please welcome ma'am.
Good morning to everyone. Let me introduce today's resource person. His name is Saurabh Kumar Jain. His designation is Partner and Patent Attorney, Senan IP. He has come up with approximately 10 years of extensive experience in patent prosecution and technology strategy research. Sir is registered with the Indian Patent Office as a patent agent and holds a master degree in telecom technology. He is having a bachelor's degree in electronics and communications along with LLB. He has extensive experience specifically within the IP domain and has worked with leading multinational and regional corporations on patent strategy. Sir is trained and mentored. Sir has been trained and mentored several patent agents and led the internal IP consulting team for patent professionals. So, sir, you can start your webinar now.
Yeah, thank you all of us. This is Saurabh Jain. I am representing Silent IP and I am a registered patent agent. So I'm just going to present a brief knowledge about what is intellectual property and how to file patent application. So am I audible to all of you?
Yes, sir. Yes.
Okay. So I'm just sharing my screen so that you all can see the presentation and entire screen. Okay. Yeah. I'm just sharing my screen. I think there is some problem in sharing the screen. So I want to share the content. Okay. Now, can you see my screen?
Yes, sir, it is starting, sir. It is starting.
Okay.
But not yet completely we have received.
It is just starting.
Sir, your screen was shared, but you have not opened the PPT, sir. You are.
Yeah. My screen is. You can see my screen now.
Yes, sir. Now it is.
Yes. Now there is a PPT on there.
Yes, sir. PPT is there, sir. Please maximize.
Okay.
Yes,
Yeah. So now we are just going to present the intellectual property and the patent filing procedure. So what is intellectual property and what is patent? How to file patent application? Right. So first of all, we would like to understand first what is intellectual property rights. What are what the things are called intellectual property rights. So intellectual property rights are those rights which are created by the human, and the creation of the human minds can be converted into a intellectual property rights. So what actually patent office or all IPR office provide to a person? They provide a protection to their creation, right? So there are lots of type of intellectual property rights can be there. Like one we can see here, patent. So patent is also a type of intellectual property. This is most widely filed by Indian applicant. The second one is a copyright. So we can file a copyright application for our book, literature, music, these all. And third one is trademark. So trademark can be filed by any company, any person who just going to start a business and want to protect the name or the logo or the slogan of their company. So these are the three widely used intellectual property rights. We will discuss in detail later. So so first of all, why intellectual property rights are needed? Why a person need to file a intellectual property rights, like need to file an intellectual property application to get the rights? So first of all, acknowledgement of the hard work of individual. If someone have done a hard work over a particular thing, then how he will get the reward? So by filing the intellectual property rights, he can get the rewards. So intellectual property rights provide the acknowledgement of hard work of an individual. It provides protection to the intellectual labor of the person. Like a person having he is working in a particular field, and he is working for more than 5 year, 10 year. So how he can get the benefit of his labor, his work? So by filing a patent application, by filing an intellectual property application, he can get the benefit of his time and work. Recognize the effort of research and development. So these intellectual property rights recognize the effort of research and development work done by a person. So this is a very innovative tool to practice, and most widely, most important thing is increase revenue. Increase revenue by filing a patent, by filing intellectual property rights. So if you file intellectual property rights, like if you have done a novel thing, you have invented something new, or you have involved in a research and development program, and you have spent your money and all your labor, your work, your time, everything you have spent on a particular product or a process, then how you can get the benefit from them? So by filing intellectual property application, you can get the benefit of these all. So you can increase the revenue from licensing that intellectual property rights, right? So without the protection of their creativity, innovation, business and individual would not reap the full benefit of their invention. If you do not file an intellectual property application, then a person cannot get the benefit of their invention, innovation, business or creativity. So intellectual property application is a very important tool to protect your invention, your creativity. Right. So what are the type intellectual property can have? So first of all, the majorly used is patent application. So patent application can be filed for any innovation, process, product, machinery. For these type of invention, a patent application can be filed. So we will discuss the type of patent application further. Patent application can be comprised of two types. First is design patent, another is utility patent. So we will discuss later on each of them. So the second one is copyright. So copyright is also a type of intellectual property right, and copyright is filed for basically music and books and these all kind of like literature. So for literature and software, if you are going to protect the code of a particular process, then you should file a copyright application for that. Right. The third one is industrial design. So industrial design also cover into the design patent application. So if you have a unique design, a specific shape of a particular product, then we should file a industrial design application. The fourth one is trademark. So trademark is this is the trademark create the brand value of a company, right? So when a particular person having a company and he wants to protect the competitor from making or manufacturing a copy of a product, then he should file a trademark application. And why filing a trademark application, their brand value can be protected. So geographical indication, this indication is filed by the government organization or NGOs uh, to protect the indication of a particular geographical area like Assam. So T, hello. So T is a geographical indication of Assam. So these type of like India currently filed a geographical indication rice and in a World Trade Organization. So India want to get a geographical indication of rice. The India has filed the application for that. And the next one is layout design. So layout design is also a type of intellectual property right. If we have a particular circuit on a PCB, then we can also file a layout design application to protect our PCB design. Then plant varieties. So plant application can also be filed to if we have invented a plant by using the combination of two or three plant, then a patent application can be filed for plant patent, right? So these are the example. We can file a patent application over such type of machine, and we can file a copyright for these type of books. And these are the few examples of trademark. And this is the example of copyright. Sorry, geographical indication. And this is the example of layout design. Right. So now we will understand what can be protected under patent, design, and copyright. These all. So under the patent, we can protect the invention. Invention such kind. What is the example of inventions? Like iPod, chemical fertilizer, process of manipulating genetic trait in mice, and the like lots of example we can have for invention like any air conditioner, like all electronics product are the invention, right? So what are the lifetime of a patent application? If you file a patent application, then the patent office, the Indian patent office, provide a protection of their invention for a period of over 20 years, and this cannot be extended. This is the fixed period of 20 years. After that, your patent application will be open and anyone can use. But within this period, if someone is using your invention, selling your invention, manufacturing your invention, then you can file a case against that person. The next one is design. So design, as the name indicates, design. So design of a particular product can be filed under the design application. So ornamental, like shape of any particular bottle. These are the example of design. Unique shape of electric guitar, design of a lamp. So what are the lifetime of the design patent application is 10 years. So for 10 years, you will get the protection of a design patent application. Copyright. So copyright can be filed for books, photos, music, fine arts, graphics, image, video, films, computer, media, these all. So these are the example we can file a copyright application for that. And the lifetime of the copyright application is lifetime of the author, or 50-60 year from his death. Trade secret. So trade secret we can file how the Coca-Cola, how the Pepsi is manufactured. So this comes under the trade secret. Trademark is a word, symbol, logo, these all slogan. So these can be filed under the trade secret application. So now we will understand, we already discussed about the copyright. So definition, any copyright is a property right, is an original work of authorship fixed in any tangible medium of expression, giving the holder the exclusive right to reproduce, adapt, distribute, perform, and display the work. So in simple language, what we can understand, copyright, if you have a copyright, you can display your work, you can sell your work without any competition. You can arrange an exhibition. So by filing a copyright, these liberty a copyright provides to an author. So if you have a copyright, then it is represented by this symbol, copyright. You have already seen, I think, this symbol at multiple places. So this symbol can be represented as copyright. So the term of protection in case of literature, dramatic, music, and artist work shall be lifetime of the author plus 60 years from his death. Right. So copyright, you have seen this. You can see the example copyright C 1982. So this is a example of copyright. Like a disclaimer. Disclaimer can also be we can file a copyright application for this disclaimer. Any literature work. So these are the few examples. So what is industrial design? So you can see industrial design, like here design of a spoon is given. So in the you can file a design patent application for a particular shape or a particular design of a particular product. So here you can see the design example of a spoon. Here you can see the design at the second end. So wherever the design is different or a unique, then you can file a design patent application for that particular product. So we already discussed, like a term of a design patent application is 10 years, and we can also renew the design application for another five years. Right. So this is also an example of design patent application. We can file a design application for this type of product. Oh, what is trademark? So trademark is like you can see these are the example of trademark. These this is a sign of Mercedes. So you can see by seeing that logo, you can get to know about which company is this. So this is the another example of trademark. So we can file a trademark application to make our company as a brand or any product as a brand. Right. So trademark application can be filed trademark application is granted for 10 years, and this can be further renewed as long as the business exists. So there is no limit for trademark application. There is no lifetime for a trademark application. So ultimately, what is patent? So this is just widely used intellectual property right over the world. So lots of applications filed for patent application. So what is patent? So patent is an exclusive right. Patent is an exclusive right for preventing manufacturing, using, selling, importing the patented product or process in a particular territory. So who provide the patent right? So government, the patent authority, the patent office of India provides the right for a patentee over a period of 10 years. So first of all, we need to understand what is the nature of the patent application. So patent application or patent rights always are territorial rights. We can generally people think about like I have filed a patent application in US, and by filing a patent application in US, I have covered the rights all over the world. So it is not so. If you have filed a patent application in India, then you will get the right inside India, not inside any other country. If you file a patent application inside US, you will get the territorial right, like within a particular country, not outside that country, right? So these are the few example. The patent application can be filed for machine and process and product, right? So we can file the patent application. So first of all, by to before filing a patent application, we should understand what can be the criteria for filing a patent application. How the patent application can be examined. So first of all, a patent application should have novelty. Without novelty, your patent application cannot be granted. So novelty, that means your product process should have new. It should not be like a copy and paste from somewhere, or it should not be derived from any literature or any publication available worldwide. And we should understand difference between the invention and the discovery. Sometimes people mix both of these, like discovery and the invention. Discovery is just merely discovering of something, and invention is invented new, that is not known prior to the date. So invention should have newness. The second one, the second criteria is inventive step or non-obviousness. So this is the second criteria of the patent application. Before filing a patent application, we should understand this thing and we should check all these criteria, whether these criteria is fulfilled or not. So first of all is novelty. The second one is non-obviousness. Non-obviousness, what is the meaning of non-obviousness? So non-obvious, that means if we have a pencil, right, and we also have a eraser, and if we want to patent a combination of pencil and eraser, like we have seen the eraser is mounted over the pencil, and we can use one product as a pencil as well as for eraser. So this thing is not patentable, because what you have done nothing. You just incorporate one pencil with an eraser, and simply make a product, simply made a product using two existing product. So this comes under non-obviousness. Obviousness. So your patent application should be non-obvious, non-obvious to a person having ordinary skill in the art. So for this person, like for any person who is having ordinary skill in the art, should not come with a solution of existing product or process to drive a single invention. The third one is it should be capable of industrial application. So your patent application, your invention should have an industrial application. Without application, there is no invention. There is no meaning of invention. So our invention should have industrial application. And some things are listed into the Patent Act. The patent is governed by a Patent Act 1970. So under section 3 and 4, there are some definition given what is not patentable, like any natural law, any invention that is against the nature of law is not patentable. Like I given you example like a perpetual machine. Without any input, you cannot get any output. This is the law. This is the against law of nature. So such type of machine or any product that is perpetual in nature cannot be patentable. And some example also like method of surgery. Method of surgery, method of treatment is not patentable. Method of playing game is not patentable. Business method is not patentable. Software application is not patentable. So we should file a we should file a copyright application for software codes. So these some few examples are given in section 3 and 4 that are not patentable. So who can file a patent application? This is a primary question. Who can file a patent application? So anyone who are living in India can file a patent application. Although the person who are living outside India can also file the patent application, but having the different rules. Indian applicant having different rules and foreign applicant having different rules. So, student, researcher, engineers, companies, research institute, educational institute, organization, ordinary person can file a patent application in India. A patent application can be filed by inventor himself or through a patent agent. So how a patent application can be filed? A patent application can be filed by inventor himself, inventor or the applicant himself, or through a patent agent or patent attorney. Government has authorized patent agent, patent attorney to file a patent application or to do all the patent related work on behalf of an applicant or inventor, because a patent is a legal process, legal work. So all formalities, all laws should be complied according to the Patent Act. So that's why Patent Office assigned this work, this task to the patent agent to look after these all compliance, all process. So how to file a patent application? So patent application can be filed in two modes. One is offline mode and another is online mode. So how to file a patent application in offline mode? Simply draft a patent application according to the patent office format and prepare the forms as prescribed in patent act, like form 1, form 3, form 5, form 9, form 18. These are some forms, form 2 as well. These are some forms need to be filled at the time of filing a patent application. So prepare all these forms and patent application in form 2. It should be in prescribed format, and file these forms and patent application to the patent office. So this is the one way of filing a patent application. There is always a government fees for filing a patent application. And the second one is online mode. So online mode can also be filed like through individual person or through patent attorney. So patent attorney has given the authority to file a patent application for many number of applicant or inventors. On behalf of them, a single patent attorney can file multiple patent applications. So if you are going to file a patent application through patent attorney, so he will take care of all the process, like preparing the form, checking the form, checking the format of the patent application, drafting a patent application. Drafting a patent application is a very critical step. So we should be very cautious about while drafting a patent application. It should be in the proper format. The claim is the heart of the patent application. So the claim should be filed a very a proper manner. If the clarity is not there in the claim or the the patent application is not going to be granted. So the claim is the heart of the invention. So claim should be drafted properly. Claim define the scope of your invention, how you are what you want to protect, how you want to protect your invention. So claim is a really very challenging task to be draft. So what document require? Like I already told you, patent application should combine at least form 1, form 2, drawing, a valid address in India, proof of inventorship, like form 5. So these 3 or 4 forms are compulsory. This is compulsory. You can see the grant certificate of grant. So this is the example of a patent certificate. When you have filed a patent application and compiled with all the format and formal requirement and novelty of of your patent application, then you will receive a patent certificate similar to this. So this is the example of patent certificate. So, how to file a patent application? First of all, this is a typical steps that we need to follow before filing a patent application. So, first of all, if you are going to file a patent application with us or with someone else who is not the inventor or the applicant. So first of all, a patent inventor or the applicant should sign a non-disclosure agreement with a third person like patent attorney or someone who is filing the patent application. So non-disclosure agreement tell like your invention is not going to be any leak. Like the person who is receiving your invention will not disclose your invention to any third party. The invention detail will be within two person, like the inventor or applicant himself or the patent attorney. He will not disclose the invention detail to anyone else. So before filing a patent application, if you are filing with someone else, so you should sign a non-disclosure agreement with him. Then you should share the invention detail, and that invention detail should be checked before filing a patent application whether the invention is patentable or not, whether the invention having the novelty or not. If the invention is do not compile with the novelty, like primary three step, novelty, inventiveness and obviousness, if the invention do not have such three important factors, then there is no meaning of filing a patent application, because the patent application is not going to be granted without these novelty, inventive step and industrial application. So first of all, we conduct a novelty search to understand whether the invention is not patentable or not, and then we will share a patentability search report to understand, and we will also give you the opinion whether then you should file a patent application or not. And after getting the search report, you can decide whether we should modify our invention, because we will have the prior art, the results that similar to your invention, and accordingly by seeing the prior art or the results, anyone can come up with a modification. So a novelty search is a very crucial step. Generally, applicant miss this step and just waste their money in these drafting and filing these government fees and the time and money all waste if you do not compile in this first step. If the first step is not fulfilled, then there is no meaning of these all steps. So first of all, this is very important step. I would suggest to everyone to first of all check the novelty and inventive step of your patent application, your invention, then go for the drafting. If the invention having the novelty or the inventive step, then we should go for the drafting. So how drafting? Why drafting is important? Drafting is really important because without a proper invention, then patent application is not going to be granted. The patent office do not grant the patent application that do not define the invention properly or clearly. So first of all this, and the second one is patent drafting also comprises the drafting of claim. So claim is a very crucial part of a patent application. If the claim is not drafted properly, then the patent application is not going to be granted. So the another aspect is like your claims. So we should understand what is the scope of the claim, what is the narrow, what is the broad scope of the claim. So if your invention having four feature, right, and your invention having the novelty in two feature or three feature, then what is the meaning of writing the fourth feature? There is no meaning of writing of fourth feature into the claims. So if you add a fourth feature or fifth or sixth feature, then you are narrowing your claim, and narrow the claims, narrow the chance of infringement of a particular product. So that's why a claim is a very crucial step. The claim should be broadened as it should be the claim we should draft. The third one is, once we check the novelty and the drafting is done, the patent application can be filed. And after filing a patent application, the patent application generally published within 18 months of filing. After 18 months of filing. So there is also way to early publication patent application. So we can file a early publication request after filing a patent application, or with the filing of patent application by filing form 9. So if we do not file early publication request, then the patent application will be published after 18 months. And if we file early publication request, then patent application can be published within 1 week, 2 week, or 1 month. Right. Then we have to file examination request. So examination request we have to file within 4 years of filing a patent application. So without filing a request for examination, your patent application is not going to be examined by the patent office. So this is just forms and formal requirement of like filing a patent application. We should file a publication request and the examination request. This is essential, and this publication step is optional. We can file early publication request, or we cannot file. This is up to us. Right, examination we have to file. This is compulsory. We have to file examination request within 4 years of filing a patent application. So after filing examination, the patent office will conduct an examination of the patent application, and the patent office will generate an examination report. So the examination report is called first examination report, that is FER. FER. So the FER will be issued by the patent office, and this FER is mailed to the applicant email address on applicant address. This FER is mailed, and the applicant need to be replied to the examination report within a prescribed period. So if you don't reply examination report, then your patent application will be abandoned. So if there is any objection into your patent application that you have already filed, then the patent office will cite that objection into your FER, and you have to answer that objection. So if you have filed the reply or response to the FER, then the patent office will again conduct an examination of your patent application and the response based on the response, and whether the patent application will be granted, or the patent office will arrange a hearing for to hear a applicant or the inventor or the agent. Applicant, inventor, agent can also attend the hearing. So a patent office allow a chance to be hear the matter, the response you have submitted over this, and based on that hearing, the patent application will be granted or rejected. It will be decided after the hearing. So this is just a simple flow chart of filing a patent application, how the patent application works. So simple, once the patent application filed, so after 18 months, the patent application is published, and within 48 months, we have to file a request for examination. Then examination of patent application is conducted. Is the patent application is ordered for grant? If the patent application is compiled with all the requirement, then the patent will directly be granted. If not, then the patent office will issue examination report. Then after issuing examination report, we already discussed about these steps. So respond to examination report, whether it will be rejected or granted. So based on that decision, the patent application will be granted or rejected. So based on the response and the hearing, the patent office decides whether the patent application is granted or no, or rejected. So this is the filing procedure of patent application. So after granting your patent application, you have granted a patent certificate. So after grant, like at this step, if you have granted a patent application, so you will receive a patent certificate, this kind of certificate. So after your patent application is granted, so if someone is using or manufacturing or selling your product or process, then you can file a case against that person. So there are few example, notable cases here we are representing, where a patent applicant can get the benefit from his invention. So in this first case, like Alcatel-Lucent filed a case against Microsoft. So what happened? Like Alcatel-Lucent awarded 1.53 billion dollar in the final verdict that comes in 2007, where the Microsoft product window media player infringed its patent. So Microsoft was having a window media player, and for window media player, the Alcatel Lucent already filed a patent application and granted that patent application. And in for that patent application, the Alcatel Lucent filed a case against Microsoft, and in that case, Microsoft lost the case, and the Alcatel-Lucent awarded 1.53 billion, approximately 1100 crore rupees. So the second one case, Apple versus Samsung. So in 2011, so Apple filed a case against a Samsung company, and the damage recovered 7-8 thousand crore rupees around. So these are few examples, and daily some cases are going on in Indian court, or Australian, or US court. So daily some cases are pending, and they are just fighting for these cases, and they are awarding some the sum of any damages. So the court decide the damage and award to the patentee. So what can be the cost for filing a patent application? So by to file a patent application, the cost may range from 10,000 to 70,000, or maybe 1 rupee, depending on the country and the patent office, patent attorney, the drafting process, these all. So this is a typical cost of filing a patent application. So if an organization having n number of invention, like if an organization want to file the patent application, an organization having n number of invention, like 100 invention in a year. So what an organization should do? So generally we suggest an organization to file a patent application in level wise. How? The level 2, and level 3. If we categorize the invention, and accordingly we decide how much we should spend on a particular patent application or a particular invention, then the patenting process, or we can protect our invention in an efficient manner. So if then we will first of all, we will conduct a novelty search to understand what is the weightage of the invention, whether we should file a patent application, whether we should file a patent application in India only, or we should file a patent application worldwide, whether we should file a patent application in India as well as in other country. So according to the strength of the invention, we can file a patent application. So generally we can also do such kind of exercise. But if you are filing only 5 patent applications, so such kind of exercise is not needed. So if we are filing 100, more than 100 patent applications per year, then we should do such kind of exercise. So this will reduce the cost of filing a patent application, and we can spend money, or our money into the potential invention, because there is no value of investing on a simple invention or a an invention having a less industrial application. So based on the industrial application, we should decide whether how much we should invest on our particular invention. So this is all about our patent system and how the patent works. You can note down if you have any query, you can just note down the email ID and the contact number. And if you have any question related to patent filing and procedure, you can just call us or mail us. We will answer your query. And I would request to all participants to ask a question. If you have any question in your mind, you can ask.
Thank you, sir. Thank you so much, sir. The session is very interesting. As we are the academicians, it is very essential for us. So we have learned a lot regarding the patents and
Yes, yes, yes. So, if any of you having any question regarding the patent filing procedure and other question in your mind, you can ask. We have some time, so I can clear your doubt.
yes, sir. Yes, sir. Yes, participants, if you are having any queries, please you can raise your query.
So if we having a private limited company, so it is applicable patent rights
Your voice is
applying.
not clear. Hello, hello. Your voice is not clear.
Yes, sir. If we are entrepreneur, so we are applicable for applying the patent rights, sir, for a private limited company or
Actually, I am not getting your question because your voice is not properly receiving at my end.
So the question is, the entrepreneurs, anyone who is
Yes,
having
yes.
a private limited company, can go
Mhm.
for filing a patent. That is the
Yeah,
question.
definitely, definitely. Any
definitely.
entrepreneur or any private limited company can file a patent application in India.
Okay, okay. That thank you, sir.
Yeah. Anyone else?
Sir, can we file a same patent in two different countries, sir? As you told,
Yeah,
it is.
yeah, definitely. We can file the same invention in two different country within a particular prescribed time. That means if you have filed a patent application in India, then within 12 months you have to file the patent application, the same patent application, the same invention outside India within 12 months. After passing the 12 months, you cannot file a patent application in any other country. So within 12 months, we can file a patent application outside India. If you have not still decided whether we should file a patent application outside India, so we can file a BIPO patent application, World Intellectual Property Organization. This is another an organization of 135 countries. So we can file a BIPO patent application to just get a time extension. So if we file a patent application in India and we also file a patent application in WIPO, then we will get a 30-month period to file the same patent application outside India or in other country. So by filing a WIPO patent application, we will get an extension of time of 30 months. Right.
Thank you, sir. Thank you, sir. Thank you. Sir, whether the patent filing policies is common in all the countries or it is different from different countries?
Sorry, can you repeat?
The patent filing policies is common for all the countries or it is
Generally,
different for different countries?
generally 80% of the law are same in all over the country. But some the patent office having the different rules, so they are not bound to be on a particular country. So they all country having a different rules. So generally 80% of the law are the same, but 20% laws are different according to the country. So US having a different patent law, and India having a different patent law, and other Australia having a different patent law, China having a different patent law. So every country having a different patent law.
Thank you, sir. So is there any other queries from participants?
What? Sorry. Which for this webinar? Patenting is never can be a free of cost. Like we should have some like we have to file the patent application according to the patent format, and we have to pay the fee for that. So for filing a patent application, there is always a government fee. And if you file a patent application, like I already described into the last slide, the patent filing cost can go around 10,000 to 70,000 of 1 lakh rupees, right? No, no, actually, once the patent application is granted, after the grant, the patent application need to be renewed. Before grant, there is no renewal fee need to pay, right? So after grant, you have to pay the renewal fees every year, or you can pay the renewal fees in one time.
So the softwares or mobile applications will also come under this patent
Yes, yes.
application.
So in India, software and mobile application is not patentable per se, but the process of particular if like you should have some process into a software application, right? So that process can be patentable.
Okay, so process like what service we are providing with that.
Like similar, like I will give you an example. So you are having an invention of identifying a particular plant by using image processing, right? So, how we should do this? We can do this using a particular software images capturing from a
Yeah,
plant, and we are identifying that plant using processing. There is a
yeah.
processor processing doing these all these things. So we cannot file a patent application based on the software, but the process, how the process is going to be happen. Like we are capturing the image, we are comparing the image with a database, and we are trying to figure out the feature, and we can ultimately we are trying to find out the type of plant. So this process, how we are doing this n number of members you can add into your patent application as inventor or as an applicant.
Okay.
Can we file a complete patent directly, or we should file as a provisional first?
So I will tell you, there are two types of patent application exist. One is provisional patent application, another is complete patent application. So provisional patent application, if you are not completed your invention, then you should file a provisional patent application, and within 12 months you have to file a complete patent application with complete invention. So failing to do this, your patent application will be amended. So if you have complete invention, then you should directly file a complete patent application. If you don't have your complete invention in your head, then you should file a provisional patent application.
Sir, you told
Right?
that it can be valid after lifetime also. So if it is like that,
No,
whether the
no,
extension
no, no. Patent application is not valid for lifetime. Patent application is granted for over a period of 20 years. The copyright is valid for lifetime of an author.
so nothing is valid after lifetime, sir.
Copyright is valid lifetime of an author.
Okay.
Patent is granted over a period of 20 years.
Okay. Is there any other queries from the participants?
So we can renew the
If
patent
we
after
are
20 years,
dealing,
right?
Yes, one by one, please.
We can renew the patent after 20 years, right?
No. After 20 year, we cannot renew the patent application, because after 20 year, the patent is free to use by anyone else. So patent office provide the right only for 20 years, not after that.
We can file the case after 20 years also, right? If someone is using our patent product by saying his name.
Hmm. Can you repeat your question?
We can also case a person who is using our patented
Yes, yes, yes.
product
Yeah, so
after
within
20
20
years.
years, within 20 year and after the grant of your patent application, if someone else using, manufacturing, selling your product without your permission, so you can ask to that person to pay the damages, or can directly file a case against that person. And if he is not ready to pay the damages, then you can file a case against that person. So that person, if he want to sell, manufacture, or use your invention, then that person should have take a license from you to do to use or manufacture or sell the product.
So if we are dealing with the government, if the invention is used to help in the government sector, will it be the patent or will it be considered in the government sector?
No, no, actually, if the invention is helpful for government sector, so you can
Yeah,
file a patent application, and it will be solely your right. You can get a patent certificate over that. So if you are filing a patent application over a defense or
yeah, yeah,
nuclear
defense.
energy, then in that case, the patent office will not grant your patent application. So your patent application should not be purely based on defense. That if the patent application will publish, then the enemy will get the knowledge about your invention. So that's why
Okay,
the government patent office do not allow to publish your patent application.
but the invention is used to help the, I
Yeah,
mean, the
if you
government
are
sector, the software.
no
I mean, the
in
software.
yeah, if your invention is useful or helpful to the government organization, then your patent application will be granted.
Okay,
There
will
is
it
no
be
problem
secret?
from
Okay,
based on if your invention is not purely on the defense sector, like
okay,
I told you, na, by publishing your invention, if your enemy or the country enemy will get to know about a particular process, how this weapon is going to be
yeah,
manufactured, then in that case, your patent application will not be published.
will not be granted. Okay,
Yeah.
okay, thank you.
Sir, who will decide the value or revenue for the granted patent, sir? Whether the inventor or the organization?
Sorry, can you repeat?
Who will decide the value or revenue of the granted patent? Or
Uh, First of all, patent attorney or any professional who is working in this field, they conduct a survey of that is called market research. So based on that market research, the value of your patent application is decided. Or and the based on that value, you can file or you can ask to anyone else to pay the damages related to your invention. So patent professional or patent agent can decide the revenue of your invention, like value of your invention, how much the market cap of your patent or invention,
for
right?
example, if the inventor is not satisfied with the revenue what is decided by the attorney,
So inventor, like patent attorney or patent professional provide an opinion. Like this is the revenue, this is the market value of your invention. If the inventor is not satisfied, then an inventor can change the revenue digits, right? So the inventor is not bound by any patent attorney or patent professional to obey their order. So if inventor thinks like my invention should have more value as compared to the determined value, then the inventor can himself add the value. So this is just opinion.
okay, sir, let us consider we have filed a patent. How can we
Mhm.
come to know that some organization is following our patent? Is there any process either from patent office or
No, no, no. Before granting a patent application, we cannot see, or we cannot like we can understand if you have filed the patent application related to a particular product like charger. a particular charger, or you can say AC. You have filed a patent application over a AC. So you can check in the market there are n number of competitor are exist like Hitachi, Voltas, Carrier. These all are the AC companies. So these are your competitor, and you should understand the value of your invention based on the market value or the product, or by seeing the net worth of the company who is selling your product, right? So we should understand the scope of the invention based on the market research, and we can understand the scope of the invention based on our experience. There is no specific criteria, there is no specific formula available to calculate the value of your invention. So we can understand, we can evaluate, we can calculate the value of your invention, your patent based on the experience and some facts about the product or the field exist on the internet. So in that basis, on that basis, we can evaluate the value of our invention.
Thank you, sir. Is there any other queries from participants?
Sir, if I have a defense company, I'm related to a defense company, private limited.
Mm-hmm.
So I'm applying for a patent right for an invention or something else.
Mm-hmm.
Will it
Mm-hmm.
be approved or will it be not?
Depend on the parent office. If the parent office allow, so they having a separate department to evaluate whether the invention is related to defense sector or not. So if they allow the parent application to be published, then your parent application will be published. Otherwise, they will generate a secrecy direction letter to you, to the
Yeah,
applicant.
secrecy.
That is secrecy
Okay.
direction letter. So in that letter, they will inform you your patent application is related to this, and your patent application cannot be published. Or after some time of after this time, you can check the status of the patent application, and so they will tell you in that letter. They will tell you the
Okay.
exact status in that letter. What is going to be happened with your patent application if this is related to defense sector,
Okay.
right?
Okay, sir. Thank you.
Okay, if there is no more queries, we will conclude the session. So, is there any other queries? Thank you, sir. Thank you so much for your valuable information. I hope this will be very useful for our faculty members. And I
Thank
believe we
you.
will come out with some new innovative ideas to file patent very soon.
Yes, yes, sure. I really happy to provide our valuable experience to all of you. And if you have really any query, if you want to file patent application and India, outside India, you already have my number. You already have my email ID. So you can just mail me, call me. So I will help you in every manner.
Sure, sir. Sure, sir. Now I would like to invite Mrs. Misbah Kozer, madam, for vote of thanks. Please welcome, ma'am.
Yes, good afternoon to everybody. On behalf of Shadan College of Engineering and Technology, from the side of Principal Sir, Director Sir, HOD Sir, faculties and students, I would like to convey my vote of thanks to Mr. Saurabh Jain Sir. Thank you, sir, for sharing your knowledge
Thank you.
and yeah.
Thank you, madam.
sir.
Thank you. It is my pleasure to join you.
No problem.
Thank you.
Your session was very much informative for all of us.
Thank you, madam. So we should end
Thank you
this
so
meeting
much.
now.
Yes,
Yeah.
sir.
Okay. Thank you, sir. Thank you.
Thank you, everyone. We will end up the meeting. Thank you so much.